An eligible person is entitled to legal services at any stage of the proceedings which he or she is prosecuting or defending. In fact, the Supreme Court Legal Services Committee provides legal assistance to eligible persons in this court. This makes it abundantly clear that legal services shall be provided to an eligible person at all stages of the proceedings, trial as well as appellate. It is also important to note that, in view of the constitutional mandate of Article 39A, legal services or legal aid is provided to an eligible person free of cost. Para. Pending the enactment of the Legal Services Authorities Act, the issue of providing free legal services or free legal aid or free legal representation came up for consideration before this court. Para. In Hussain Nara Khatun versus Home Secretary State, it was held that free legal service is an inalienable element of reasonable, fair, and just procedure for a person accused of an offence, and it must be held implicit in the guarantee of Article 21. It was noted that this is a constitutional right of every accused person who is unable to engage a lawyer and secure free legal services on account of reasons such as poverty. It was held that the state is under a mandate to provide a lawyer to an accused person if the circumstances of the case and the needs of justice so require, subject, of course, to the accused person not objecting to the providing of a lawyer. Para. In Khatri and others within bracket 2 versus State of Bihar, it was noted that the judicial magistrate did not provide legal representation to the accused persons because they did not ask for it. This was found to be unacceptable. This court went further and held that it was the obligation of the judicial magistrate before whom the accused were produced to inform them of their entitlement to legal representation at state cost. In this context, it was observed that the right to free legal services would be illusory unless the magistrate or the sessions judge before whom the accused is produced informs him of this right. It would also make a mockery of legal aid if it were to be left to a poor, ignorant, and illiterate accused to ask for free legal services, thereby rendering the constitutional mandate a mere paper promise. Para. Sukhdas versus Union Territory of Arunachal Pradesh reiterated the requirement of providing free and adequate legal representation to an ingredient oblique indigent person and a person accused of an offence. In that case, it was reiterated that an accused need not ask for legal assistance. The court dealing with the case is obliged to inform him or her of the entitlement to free legal aid. This court observed that it was now settled law that free legal assistance at state cost is a fundamental right of a person accused of an offense which may involve jeopardy to his life or personal liberty, and this fundamental right is implicit in the requirement of reasonable, fair, and just procedure prescribed by Article 21 of the Constitution. Para, since the requirements of law were not met in that case and in the absence of the accused person being provided with legal representation at state cost, it was held that there was a violation of the fundamental right of the accused under Article 21 of the Constitution. The trial was held to be vitiated on account of a fatal constitutional infirmity, and the conviction and sentence were set aside. Para. We propose to briefly digress and advert to certain observations made both in Khatri and Sukdas. In both these cases, this court carved out some exceptions in respect of grant of free legal aid to an accused person. It was observed that there may be cases involving offences such as economic offences or offences against law prohibiting prostitution or child abuse and the like, where social justice may require that free legal services need not be provided by the state. We have some observations whether such exceptions can be carved out, particularly keeping in mind the constitutional mandate and the universally accepted principle that a person is presumed innocent until proven guilty. If such exceptions are accepted, there may be a tendency to add some more, such as in cases of terrorism, thereby diluting the constitutional mandate and the fundamental right guaranteed under Article 21 of the Constitution. However, we need not say anything more on this subject since the issue is not before us.